Welcome, and let's take a look at question 5 from July of 2013. It's straight wills, and again, with wills questions, they're not very difficult. In fact, there's certain essay subjects where I believe if you get them on the bar, count your blessings. You have to be really strong with them and tight with your analysis and your rule statements because they are, well, some people do have trouble with them, but I don't think you guys will have any trouble with wills. Now, one of the things I forgot to mention, before you listen to this, make sure you read the fact pattern 2 or 3 times before you start. So if you have to, pause the video right now, read the fact pattern 2 or 3 times to become familiar with it, because this way when I go through it, it'll be more fluid for you to understand what's going on. Okay? Because sometimes I might move a little quick. What rights, if any, do B, S, D, and Cindy have in Ted's estate? So we have 4 calls of the question, technically, and that's how we're going to answer it. Bertha, Sam, Dot, and Cindy. So these are our 4 beneficiaries, if you will, and they're all trying to get their dirty little paws on Ted's money. So let's see what happens there. Let's take it from the top, and with almost every wills essay, happens in community property, it happens in contracts. Notice that the first paragraph starts in 2000, third paragraph in 2010, then 2011, then 2012. I mean, just go in order. It's not that difficult if you literally just go in order. So that's how we're going to start it. We're going to get to answering these guys later, because when you have situations like this, I think the best thing to do is go through the entire fact pattern chronologically. Then you'll be able to answer B, S, D, and C. So this comes after we go through the fact pattern. So watch this. Okay. And this is exactly the way you're going to organize it when you write it. Start with the 2000, because that's the way, that's where it's going to have to be your starting point anyways. You can't go through and just find what's going on with Bertha or Sam. Besides, probate court's going to consider the whole estate and then start dicing off the pieces to people. After they figure out what will to probate and who gets what under each will, that's how they're going to get it. So it only makes logical sense to do it this way. Ted was married to Wilma. Wills is often, well, sometimes crossed over with community property and trust. Those are the 2 subjects that wills tends to cross over with. And now when I see that he's married to Wilma, I'm thinking to myself, we have community property issues. Turns out we don't, but at least I'm thinking to myself, well, they usually tell me the person's a widower or a widow or single or whatever the case is. Now they're saying he's married. They're actually bringing up another issue, but that's something to think about. Why are the examiners telling me this? Are they getting at community property? Well, they are kind of a little bit getting at community property, but that's really solved easily because he gives his community property to his new wife. So he's married to Wilma, whom he had a child, Cindy. Okay. There we go. So if you wanted to kind of draw a little family timeline, T, W, and then she had a child named Cindy. All right, they had a child, Cindy. So Cindy is theirs. Wilma had a young son, Sam, from a prior marriage. So we have a stepkid in here, Sam, from a prior marriage. So Ted typed a document. So what's our first issue going to be? You know, the weird thing is here, I have no idea why. I don't know if the examiners are getting at something, but both released answers, and those are the examiner's clues to tell you what they were looking for, had mental capacity as an issue. I don't see it being an issue, but since both answers had it, and because it has become more of a prominent issue in recent years, in the last 5 to 6 years, mental capacity has showed up quite often on the essays. So the selected answers started with mental capacity, and if you didn't bring it up, completely understand. I would have never brought it up had I not been triggered by the answers after the fact. But just so you know, for mental capacity, very simple. It's very low. And you have to know you're making a will. Know it's a will. You have to understand the value of your assets and who your family is. His family and friends, you know, just anyone who's your relatives. Do you understand, like, if my dad and my stepmom and my little brother were sitting in the room and I had no idea who they were because I'm so senile, probably not competent to make a will. But here, he knew he's making a will. He knows the value of his assets because he dices it up pretty well. And he knows who his family members are because he specifically names them. So I can't see mental capacity being an issue. I have no idea why they brought it up. Big question mark in my mind. I would need to have been in the calibration session to understand why they selected those 2 answers. But that's neither here nor there. That's a minor point in my opinion. Okay, so the first issue we're going to get to really is he typed a document. So we have formal execution. Because if it's typed, it's not handwritten. If it's not handwritten, it can't be holographic. So the question is, was it formally executed? And that's where we go to plus. That means the presence, lifetime, understand, and signature. How easy that gets. And it really does. I mean, think about it. But here's going to be the main one. The joint presence of two witnesses at the same time. Focus on the testator. This is a great essay to show you how formally executed works with the joint presence of two witnesses. Now, Ted must sign the will in front of two witnesses at the same time. They both have to be there when he signs the will. Or they both have to be present when he acknowledges his signature on the will. Or they both have to be present when he acknowledges the will. So that is the joint presence. That's what this means. And it is by far the most heavily tested issue of of the formal executed will. Okay, so he typed a document entitled Will of Ted. Clearly he knew he was making a will. He says, it's a will of me. Then he dated and signed. Well, great, it's good that he signed, so we got the signature one. Check. Dates, not necessarily. It's great to have it. It always helps to have a date. Ted's will provided as follows. Okay, so let's take a look at what his provisions are. $10,000 to my stepson. Stepson? Ah, he must mean Sam. He doesn't name Sam. He says stepson, which actually plays a part later, and that's what they were getting at with the whole married to Wilma thing, why they had the son, why she had a kid. We'll explain how that worked. But stepson, remember, look at the language being used because the court's going to look at it. This was in 2000. It's now 2012. Well, this essay is in 2013. He dies, I think, in 2012. That's why I say it's in 2012. 12 years later, he doesn't have a stepson anymore. We'll show you how that works out. I give a $10,000 to my friend Dot. Okay, so I get $10K to Dot. I leave my share of all my community property to my wife. Okay, notice it says wife. It doesn't say Wilma, it doesn't say Bertha, it says wife. He's using generalities. But here's the thing about a will. A will speaks at the testator's death, which means if he doesn't die, this 2000 will is immaterial. It doesn't matter. It only matters when he dies does the will come into existence. It speaks. However, the will gets interpreted on the day that it was executed. So the court's going to look at, well, who was his wife in 2000? Who was his stepson in 2000? Now in 2012, when the will actually speaks, it gets interpreted and construed on the date that it was executed. So that's what the court's going to look at was, did he have a stepson in 2000? Because he clearly doesn't have one when he dies. Yes, he did. And who is the stepson? It's Sam. So you're going to easily be able to show extrinsic evidence to explain who the hell is her stepson, or who was his stepson in 2000, even though he doesn't name it. And who was his wife in 2000? It was Wilma. Okay. I leave the residue, and the residue just means, okay, I'm sorry, what does his wife get? She gets a CP. And the residue is anything that remains in your estate after all this is paid off, whatever's in the residue, that's what remains, the catch-all, if you will, to my daughter, Cindy. So there's no pre-terminated child issues because he specifically names his daughter. He knows he has. Sam would not be a pre-terminated child even if he didn't give Sam anything because he's not a child. He's a stepson. Unless he's adopted, he doesn't count. I leave the residue consisting of my separate part of my daughter, Cindy. I hereby appoint Jane as executor. So we have executor Jane. So Jane makes sure that the estate's paid, the will's probated, that the creditors are at bay, that everyone gets their money. That's her job, to distribute the assets, to make sure everything's taken care of, to just manage it. We have a neutral person in there who's supposed to be unbiased. That's what executors do. Okay, Ted showed his signature on the document to Jane and Dot and said, this is my signature on my will. So they understand because he's alive, it's during his lifetime, would you both be witnesses? Stop right there. Has Ted signed the will in the presence of two witnesses? No, because he had signed it prior. Did he acknowledge his signature or acknowledge the will in the presence of two witnesses? Yes, he did. End of story. Formally executed is complete. No need. And the examiners actually, it's interesting. I know some people will tell you to throw everything in there. Don't do that. Because the examiners specifically were looking for whether or not, especially if you didn't, put the substantial compliance doctrine in. Because if you did, they saw that you didn't understand that it was formally executed. That's a dead giveaway that you didn't know it, you got it wrong. Because what they're really looking for is they're not looking for perfect rule statements. They're actually seeing, did you apply the law correctly? Did you know what the law is, and did you apply it correctly? And this is a great example of that. And I don't care what anyone tells you, they are 100% wrong if you don't subscribe to this theory, because it is 100% accurate. Both answers selected didn't have anything to do with substantial compliance. Why? Those are the two perfect answers because the examiners were not looking for it. Now, technically, are they going to take off points? Well, they don't do points. They do holistic grading. But in my mind, if I saw substantial compliance, and in the grader's mind, I assure you, because they give when they release these answers, that's their way of telling us what they're looking for and what they're not looking for. So if you put substantial compliance doctrine and decided to be safe and go down that path, you just did yourself a world of hurt. You wasted time, and you showed the examiner, the grader, that you really don't understand what you're doing because it was validly executed. There's absolutely no reason to go down that path. Now, Jane signed her name. Dot was about to sign when her cell phone rang, alerting her to an emergency, and she left immediately. But wait, what about the fact that both witnesses didn't sign at the same time? That's not a requirement for formally executed. We don't care about the witnesses signing at the same time. We only care if the testator signs in front of both witnesses, if the testator acknowledges his signature in front of both witnesses, or if the testator acknowledges his will in front of both witnesses, which is exactly what happened. So, Dot was about to sign. She left immediately. The next day, Ted saw Dot. He had his will with him and asked Dot to sign. Now notice something. Dot and Jane are the two subscribing witnesses. Well, hold on. Dot is a beneficiary, and Jane is the executor. These are two separate issues, and the examiners are absolutely looking for you to separate them. First thing is, Dot, the fact that she's a beneficiary, does that cross out, eliminate, void, eradicate the formal execution? The answer is no. It just creates a presumption of undue influence. So the people that don't want Dot to take, it would probably be Cindy, because she'll get the 10,000 and it'll slip down there if Dot doesn't take. She's going to have to prove that Dot exercised undue influence over Ted in order to get the $10,000. And by the way, his estate was worth, what, $900,000 or something like that, or $600,000? $10,000 to a friend? No. So even though there's a presumption that the gift by Dot was procured by undue influence or fraud, it's easily going to be overcome because of their friends. She didn't do anything, in fact, to overcome his will. It was a small amount considering the size of his estate, and I think even Jane will be able to testify that Dot had nothing to do with this because Ted's the one who approached her. She didn't sit there and nag him to death until he hadn't given her any money. Now, what about the fact, so that was issue one, because we have to discuss Dot and Jane as both being interested witnesses. Dot's going to easily overcome the presumption. Jane is a different issue altogether, and the issue is this. If you take a gift under the will, there's a presumption that you're an interested witness. But Jane is not getting a gift under the will. Jane is taking in a fiduciary capacity. And when you take under a fiduciary capacity, even though you're getting paid, it's not a gift. It's a fee that has to be earned. Jane has to earn this, so the interested witness presumption, which means that it was procured by undue influence, doesn't apply when you take in a fiduciary capacity. So if you're the executor, the trustee, the lawyer, however you want to slice it, you're taking in a fiduciary capacity, and even though you're getting paid, because Jane's going to get paid. Oh, don't think that executors don't get paid. Why do you think people are lining up to take that job? It's a risky job, and you have to be very conservative, but she's going to get paid for this, and she can always renounce it. Hey, I don't want to be the executor, but if she's going to be the executor, she got fiduciary duties. She's not an interested witness, so her signature is totally fine, and so is Dot's. The will has been formally executed. Interesting, you have to put that together, and you have to separate Jane and Dot. Okay. That was 2000. Boom, we're done with 2000. Cool. 2010, Wilma died, leaving her entire estate to Ted. Okay, now Wilma's gone, so the gift to the wife, it's not something you're going to discuss because we'll see how that goes. But let's just say, for argument's sake, that he never remarried. Well, what happened to the gift to the wife, the community property? Well, you're thinking, oh, it will lapse because the beneficiary died before the testator, and then the anti-lapse will save it because she left a kid, she left Cindy and Sam. Anti-lapse actually only applies to people that are blood relatives. Your wife is not a blood relative. But you're not. Unless, of course, you live in Kentucky and you married your sister, but that goes without saying. But just a little this is outside the essay. I'm explaining something about wills. Anti-lapse does not apply when the gift goes to your wife, because your wife is not kindred. She's not a blood relative. Or else you wouldn't be, unless you're having sex with your sister, you wouldn't be having a blood relative. So that's interesting to think about. Okay, 2011, he married Bertha. 2012, So the 2010, 2011, there's really nothing to discuss there. 2012, it says 10 wrote in his own hand. If you can't see handwritten, wrote in his own hand is bringing up holographic wills. Sorry, you don't deserve to be an attorney. Holographic will. So what do we need for a holographic will? We need material provisions, which are names of bennies, beneficiaries, and you need the gifts. What are you giving them? And then you need, of course, a signature. So it's their own handwriting, material provisions in the own handwriting. I guess the best thing is material provisions in own handwriting. Because there was an issue back, I don't know, I think it was around 2004, where the guy, or 2002, where the guy crossed it out. He just wrote the amount. He did not write the names of the beneficiaries. So that didn't, the material provisions were not entirely in his own handwriting. But here we have, wrote in his own hand, I am married to Beth, and all references to my wife in my will are to Bertha. He signed and dated the document. So we have a valid holographic codicil. And then what he's doing here is he's discussing the 2000 will, and he's changed it. So although the examiners weren't looking for like any kind of revocation, because he didn't revoke it, he just changed it. He just amended it. And that's what codicils do. They amend it. So it's technically a valid holographic codicil. Codicil and will pretty much means the same thing. A will is the full disposition. A codicil is just an amendment. Technically, this is an amendment. So it's a holographic codicil. So he is now mentioning the 2000 will, so he's incorporating it by reference. Because in order to probate the 2012 holographic codicil, you have to incorporate it into the 2000. Now it's not integrated because he didn't staple them all together or paper clip them together or put them all in the same folder together. So integration doesn't actually show up as an issue. Incorporation by reference does. It has to be in existence and sufficiently described. And there we go. Is the 2000 will in existence? Yeah, it was from 2000. And is it sufficiently described? It says, I am married to Bertha. All my references to my wife in my will. He only has one other will. So it's not ambiguous. It's not like he has 3 different wills. He only has one other will, and that's the 2000 will. So that's sufficiently described. If I told you like my car, and I had one car, that's sufficiently described. Or I go, hey, you pass the bar, I'll give you my house. If I only have one house, then you know which one we're talking about. Okay, existence sufficient to describe. Perfect. And that's the same thing with real property. They do that concept. If you say my house on Maple Street, and you only have one house on Maple Street, sufficiently described, even though you don't give the meets and bounds or the actual physical address or lot number. Guys, don't make this stuff so much. It's not complicated. It's pretty simple. Okay, so the 2000 will is incorporated by reference, and what else we got? I think that's it. Okay, so let's take a look. It says, recently Ted died with an estate of $600,000, consisting of his 1/2 community property share of $300,000, because when he died, Bertha already gets $300,000. So his $300,000 he can do what he wants with, which apparently he gave to her. So she's going to end up getting, so wife's going to be Bertha. She's going to get all $600K. Plus, so $600,000 home he owned to Bertha, that's what she'll get. Plus $300,000 in a separate property bank account. Okay, well, he kind of divides up the separate property. So here's Bertha. So now we actually attack B, S, D, and C. We'll do it down here. This way. All right, so let's take a look at B first. What does B get? Well, first of all, B's going to get his wife Bertha. The 2012 will says so. So she gets all the community property. So she gets all the community property, which I believe, how much was that? Okay. So she gets all the community property, and I believe that's $600,000 if I'm not mistaken. Okay. Number 2, and if you don't know the exact numbers, you don't have to put it. Just say she gets all the community property, that's fine. The core will deal with it. Now Sam, well, Sam is his stepson, and he got $10,000. But it only says stepson, so you have to, this is where you discuss, the will speaks at death, but it's construed in light of the circumstances at the time it was executed, which means in $2,000, and you're going to have extrinsic evidence to explain the ambiguity, because stepson's ambiguous. I mean, what if Bertha had a couple of kids that he married? He obviously likes single moms, so say he took down Bertha. Bertha had a couple of kids, and the will still said stepson, and everything else was the same. Well, the court's going to look at, well, what did he mean by stepson? Clearly, he's going to look at the 2000 will and go, oh, he meant his stepson from 2000, so that's why Sam's going to end up taking the $10,000. So that's what they're getting at under S, and you can use extrinsic evidence to explain it. It only makes sense. Now Dot. Dot's going to get, and this is where you talk about the interested witness. She's an interested witness, but that's okay. Overcome the presumption. She'll get $10,000. And another thing that's significant too is, in 2012, when he changed his will by himself, he still left Dot in there. So that clearly shows that he wanted her to take the $10,000. It wasn't like in 2000 she was just all over his case and nagging him that he had to give it to her. And then in 2012, he's like, finally, away from that. Because if everyone's had someone in their life that they didn't want in their life anymore, we've all been there. 12 years later, you're like, whew, you would change your provision. You like, get that person out of there. He clearly didn't do it. He likes Dot. The presumption's overcome. She'll get the $10,000. And what does Cindy get? Good old Cindy. She's going to get the residue, whatever's left. And that's all that remains in there. So Bertha's going to get the $600,000 home. Sam and Dot will get their $10,000. And Cindy will take what's left, which actually turns out to be $300,000 minus 10 minus 10, $280,000. And that's it. That was the end. That's the end of it. So there's a lot of good things in this essay. It's a very good one to review. So hope you got to understand it for a lot of reasons. Okay, that's a wrap. 2013 July, Wills question 5. Thanks for listening.